Bill Henshaw again, your friendly local constitutional coop from San Francisco, and a very important subject matter for this video is that, and those of you that know and been, have been challenging the system, and you walk into their corrupt courts, there's no chance because they got the black robe bastard in there to rule against you, and the couple local dumbass and or mortgage bankers and or corporate landlords that know they're going to get the black robe bastard to rule in their favor, even if you correctly challenge jurisdiction. It won't be heard there. But the reason for that is they're not judicial courts. And instinctively, most of you probably know that, but you don't know why. And that's what I'm here to tell you. It's how important this video is, because we have a right to a judicial court from day one. Doesn't matter whether it's a quote unquote state, the federal government, whoever the hell it is, we have that right. And if we succeed in getting that, the ball game is over. Because among other things, with my constitutional defense document, it's modestly priced. You get 500 jury instructions. We're the one to instruct the jury on the law, not them. And the jury has the power to rule on the facts and the law, something they never want you to know or figure out. And that's how important it is. And since we're not in any judicial courts, and there aren't any, the first question you might ask yourself is, what are we supposed to do? Well, guess what? In California, it's in black and white. And in my view, the same thing can be said for all 32 of the original states admitted prior to 1860. And I think we have a hell of an argument for those states admitted after that the Supreme Court will understand and get right and rule in our favor. But that said, if we don't have any judicial courts, the original Constitution here, 1849, and as you'll learn, we have the California Secretary of State, the office that would officially know, saying that that Constitution of 1849 has not been repealed. Now, if that's true, then we have the California District Court, a recognized court by the California Constitution, Common Law Court, Ex parte Nolles, 5 Cal 300. And that's there, and it has full jurisdiction, and even better, what it also has is a federal circuit court within that constitutional common law court. Now, in an earlier era in the 19th century, those federal circuit courts would typically be in federal district courts. And at the time, those were judicial courts. They're not now, and we can prove every bit of it. You're going to love it. So we get into this California District Court, or the equivalent in your jurisdiction. And what we do is we take over the vacant office of the California District Judge, and at the same time, the vacant office of the Federal Circuit Court Judge. And we issue our own orders in our own court. How is that for a breath of fresh air? And yeah, the veterans are going to get effective service process, which is a hell of a lot more than you get. And just a quickie about that, when you get it, usually your name is in all capital letters with the CA or the TX or whatever it is, and the zip code. No service to process. You got fucking served in Washington, D.C., my former hometown. That's where they all think we are. I have a constitution as an example, Article 2, Section 1. Qualified electors, United States citizens who reside in Iowa. No, they don't. They reside in the District of Columbia. And if any of you out there are in anything that purports to be a sovereign independent state, then you have a domicile in a state judicial district. And none of their BS process from Washington, D.C. can penetrate that, because we have creator endowed inalienable rights that they can't tackle. That's a hell of an objection to all of it, and the Supreme Court gets it. It's called the Pennoyer Rule. That's Penorio v. Neff, 95 U.S. 714. And that's one of the big tools you can use to get these bastards off your backs. And the big deal about that is not just you going in there, because they're speaking as I am when I go in there for all of us. And we get the Supreme Court to decide one case like this on any of these issues. It puts these corporate bastards out of business from Portland, Maine to Portland, Oregon. And about time. That's how good this stuff is. So yes, we act as our own judge in our own court. But think about it. That's exactly what they're doing to us, but without any authority whatsoever to do it. Consent of the governed. And also the Supreme Court says voluntary, knowing, and intelligent waiver of rights. Johnson v. Zerps, 304 U.S. 458. Where the hell is it? They think it comes from your monetized birth certificate. Ain't. Application for social insecurity benefits. Marriage license. You need a license to get married? You know what the legal definition of license is? Permission granted by competent authority to do an act that without such permission would be illegal, a trespass, or a tort. You need their permission to get married. Well, with the license, I guess you do, but in the earlier era, and thank God I have my paternal family Bible. It goes back all the way to 1855. And when I was new at this, I asked my dad to send it out to me, and I asked him to leave it to me, which he did. And I was charged with contempt of court for not trying to help out a friend in traffic court, but practicing law without a license. So I show up at the hearing with this family Bible, and I'm sitting there waiting for the judge, Velocity, to come in. He comes in, a black boy bastard sits down, starts flipping through some papers, looks up, sees me with an obvious vintage family Bible. Bang! Down comes the hammer. Have a nice day. Don't do it again. I could prove I wasn't subject to their jurisdiction. And he didn't know that Bible went all the way back to 1855, prior to the war between the states. On my mom's side, and I love to have that family Bible, but something happened to that, I think, before I was even in the mix. But she told me, no reason to disbelieve her. On that side, I'm related to Thomas Jonathan Stonewall Jackson. And also to Light Horse Harry Lee. Most of you won't know who he was. You know who his son was. Robert E. Lee. And yes, we were doing the right thing with the war between the states. And yes, it wasn't about slavery. That's all they teach in the goddamn school system these days, and none of it is right. It was an issue, and just like with the 14th Amendment, by the way, with all these valuable civil rights, the New York bankers couldn't have given a rat's ass about the freedmen in the southern states. All they wanted them to do was be able to vote, as ignorant as they were, and take the political power away from the southern states so they could do exactly what they've done in the last 150 years. So you'll learn more about that in other videos. That's, wow. Just none of it makes any sense. But to go this way and to do it the right way and create our own judgments in our own courts as members of the sovereign body politic and in a principal and agent relationship with those in government, we have the authority to do it. To learn more, send me an email, youwinnincourt@gmail.com. Remember to subscribe, like the videos, tell your friends, get the word out. The quicker we start to take this type of action in particular, the sooner we get these bastards off our backs. Thank you.